Hello and welcome to An Academy, a one-stop destination for the English medium civil services aspirants. Welcome to yet another episode of The Nuanced, an initiative where we present a nuanced understanding of complex topics. What is citizenship? You owe your allegiance to the nation, to India, and in return, the Indian state has to legally accept you as her citizen. This is what we call citizenship. And citizenship determines an individual's full political membership in a country. Two conditions. You owe your allegiance to India, and the Indian state has to legally accept you as her citizen. And once that happens, then you can enjoy all the civil and political rights. Professor Hannah Arendt would say citizenship is the right to have the rights. Once you are given citizenship, then you have the right to claim other rights. When we look at citizenship, it comes under Part 2 of the Constitution, dealing with Articles 5 to 11. Normally, citizenship as a matter is not dealt by the Constitution. It is left to the political class. It is left to the legislature to enact laws and through which you can define all rules related to citizenship. But India is unique. Why? Because the country witnessed partition along the grounds of religion, unfortunately. The country was partitioned and two new countries were born. And at the time of the commencement of the Constitution, we had to be absolutely clear who are the citizens of India. So when we look at Part 2 of the Constitution, which talks about citizenship, normally this chapter citizenship is left to the legislature, is left to the parliament. But in India, this chapter is specifically mentioned in the Constitution. Why? Because the country was partitioned, unfortunately on the grounds of religion. And we have to be absolutely sure at the commencement of the Constitution who is the citizen of India. That is why when we look at Articles 5 to 10, listen to me carefully. It talks about who is the citizen of India at the time of the commencement of the Constitution. On 26 January 1950, who can be the citizen of India? Who cannot be the citizen of India? But after that, Article 11 comes into the picture. And it is this Article 11 which gives power to the Parliament. That what Parliament you can do, you can enact a law. And through this law, what you can do, you can regulate all matters related to citizenship. And that's exactly what Parliament did in the year 1955 when the Citizenship Act was passed. And it is this Citizenship Act which has been amended multiple times. The most recent in 2019 called the Citizenship Amendment Act for which the rules were made yesterday and notified by the government, and now CAA has been implemented. So what are we talking about? We are talking about two important concepts, Jus Soli and Jus Sanguinis. What does that mean? Law of the soil. There are countries where once a child is born, the child is a citizen only because of the fact that the child was born on the soil of that country. Jus Soli. For example, United States. No matter what the nationality of your parents, if the child is born on the soil of United States, the child is a US citizen, a US national. What about India? Till 1987, we were following this concept of Jus Soli, where if the child is born on the soil of India, doesn't matter what is the nationality of the child's parents, whether the parents are Indians or not, the child is born on the soil of India, the child is an Indian. It was only after 1987 that another requirement was added. The child born on the soil of India would become the citizen of India if one of the parent is an Indian. That means from law of the soil, we transition to law of the blood, Jus Sanguinis. But then 2003, another important change was made. A child born on the soil of India would become the citizen of India if one of the parent is an Indian, if both parents are Indians, and the other parent is not an illegal migrant at the time of the birth. Under no circumstance can an illegal migrant become the citizen of India. Can a child born to an illegal migrant become the citizen of India? Because we follow the concept of Jus Sanguinis. But now listen to me carefully. These concepts are very important so that we can understand these rules which have been notified. We can understand the law which was amended in 2019 called CAA. When we look at Article 6 of the Constitution, listen to me carefully. There were two waves of migration which took place from Pakistan to India and from India to Pakistan as well. When the country was to be partitioned, millions of people migrated from India to what became Pakistan. Millions migrated from what became Pakistan to India as well. But there were two specific waves of migration. First in 1947, or should we say the 1st of March 1947, where people from West Pakistan migrated to India. And who were these people? These were the people who predominantly were either Hindus or Sikhs, and they came in millions back from West Pakistan to India. And there was also migration of people from India to what became Pakistan, and predominantly these were the Muslims. And the property which was left by Muslims, that property came to be known as the evacuee property. And then this property was being used, these homes were being used by those migrants who came from Pakistan to India. But then there was another wave of migration. July 19, 1948. And this date is very important for you to understand what is happening right now in Assam, to understand the Assam Accord. Now, after this date, we saw another round of migration. This time, people from West Pakistan or Pakistan came back to India. But previously, these were the Hindus and Sikhs who came, who migrated from Pakistan to India. Now, these are the people who are Muslims, who felt disillusioned with what they saw in Pakistan and they wanted to return. This is where the Home Minister, the Deputy Prime Minister, Sardar Patel, is writing letters to Pandit Nehru, the Prime Minister, saying we might see some problem if these people are allowed to return. Because they left property known as the evacuee property, which was being used by people who migrated in 1947 from Pakistan to India, predominantly Hindus and Sikhs. Now, if these people will come back to India and they will also start claiming property which they had left, it will create problems. And this is where permit system was introduced. That is why Article 6 of the Constitution says, what about the citizenship of those who migrated from Pakistan to India? If you have migrated before this date, you are the citizens of India. If you have migrated to India after this date, then you had to register as the citizen. And basis this permit system, your citizenship may also be rejected. You may not be granted citizenship. This cutoff date is very important. What are we talking about? We are talking about citizenship. And what is citizenship? In the words of Professor Hannah Arendt, citizenship is the right to have the rights. Constitution under Part 2 talks about Articles 5 to 11, but it basically talks about citizenship at the time of the commencement of the Constitution. On 26 January 1950, who is the citizen of India? Who can be the citizen of India? Who cannot be the citizen of India? What will happen to those who migrated from India to Pakistan? What will happen to those who migrated from Pakistan back to India? But after all, it is Article 11 of the Constitution which gives power to the Parliament to enact law. And through this law, you can regulate all matters related to citizenship. And that is how Parliament enacted a law called the Indian Citizenship Act of 1955, which has been amended multiple times, the most recent in 2019, known as the Citizenship Amendment Act. According to this law, who can be the citizen of India? And there are various categories: by birth, by descent, by registration, by naturalization. Who can be the citizen of India by birth? Till 1987, we were following the concept of Jus Soli, which means whoever is born on the soil of India becomes the citizen of India, regardless of what is the nationality of her parents. But then 2003 onwards, the child born today on the soil of India would become the citizen if one of the parent is an Indian and the other is not an illegal migrant at the time of the birth. And at the same time, we need to understand something called naturalization. That means even if you are not born on the soil of India, even then you can apply for Indian citizenship. You may be the citizen of any other country. For example, Adnan Sami became the citizen of India through naturalization. But for that, there are strict conditions. You should have ordinarily resided in India for 14 years. You should have the knowledge of any of the languages mentioned in the 8th schedule of the Constitution. You have to give up your previous citizenship. You have to renounce your previous citizenship, so on and so forth. Why naturalization I'm insisting on? Because we have to discuss something important later. But then, the year was 2019. Citizenship Amendment Act was passed. What the Parliament basically said, if you are from Pakistan, Afghanistan, and Bangladesh, but you belong to the 6 religious minorities in these countries: Hindus, Christians, Buddhists, Jains, Sikhs, and Parsis. And if you have entered India on or before December 31, 2014, you will not be treated as illegal migrants. That means even today, illegal migrants are not eligible for citizenship. But if you are from Pakistan, Afghanistan, Bangladesh, and if you belong to the 6 religious minorities from these 3 countries, and if you have entered India on or before December 31, 2014, you will not be treated as a legal migrant. When you are not treated as a legal migrant, which means you are eligible for citizenship. And you are eligible for citizenship through a route known as naturalization. Listen to me carefully. What about other illegal migrants? When other illegal migrants are identified, they're arrested, the case is taken up in tribunals. Then these tribunals will decide whether you are an Indian or you are a foreigner. If you are declared non-Indian, then you may be deported again. What will happen to these migrants from Pakistan, Afghanistan, Bangladesh? They may have entered India in 1970s. Against them, cases may also be continuing in the tribunals. What will happen to them? From what date will they be declared as the citizens of India? The law says from the date they entered India. From the date they entered India, they shall be deemed as the citizens of India. And if against them any case is ongoing in any tribunal in India, that case will also be closed. But then there were some exceptions. Exceptions? This act will not apply to the tribal areas, those tribal areas under 6th schedule of the Constitution, dealing with 4 states: Assam, Meghalaya, Mizoram, and Tripura. That means these migrants who are now the citizens, they will not be made to settle in the tribal areas belonging to Assam, Meghalaya, Mizoram, and Tripura. Now you might ask, sir, then why is Assam protesting today? Why is there a call for Hartal today in Assam if this law does not apply to Assam? The law applies to Assam. You need to understand, not the entire Assam is under Schedule 6. There are 3 districts in Assam which are under 6th schedule of the Constitution. 3 districts in Meghalaya, 3 in Mizoram, 1 in Tripura. Total, there are 10 districts in these 4 states which come under 6th schedule of the Constitution. Which means this law will be applicable to other areas, other districts of Assam, except the 3 tribal districts under 6th schedule of the Constitution. And this law also will not be made applicable to those areas which come under inner line permit. For that, you may have read the Bengal Eastern Frontier Regulation Act of 1873. What it talked about? It talked about that there are tea plantation gardens in Northeast. There are the tribal areas of the Northeast, the mountainous regions of the Northeast. People from plains of India cannot enter these tribal areas without the permit system. That is what is called as inner line permit. And this permit system extends to Arunachal Pradesh today, Mizoram, Nagaland, which means this Citizenship Amendment Act will not apply to these areas as well. And the government said, we will extend inner line permit to Manipur as well. So these are the exceptions to Citizenship Amendment Act of 2019. And then there are 2 strong viewpoints on this. One section, they praise this law. There are critics who criticize this law. Let's look at the arguments of both critics as well as those who praise this law. Number 1, this is a law to confer citizenship. This is not a law to deprive Indians of citizenship. When CAA was passed in 2019, there were a series of protests in different parts of the country, particularly by the Muslims. Indian Muslims are in no way affected by this law. Why? Because this law does not talk about that Indian Muslims will be deprived of their citizenship, and instead Indian citizenship will be given to the migrants from Pakistan, Afghanistan, Bangladesh who belong to the 6 religious minorities in these countries. No. Indian Muslims are in no way affected by this law because this is a law to confer citizenship. This is not a law to deprive Indians of their citizenship. That's argument number 1. Argument number 2, there are critics who say Article 14 has been violated by this law. Article 14, which talks about equality before law. Law has to be equally applicable to everybody in India. And Article 14 is applicable to aliens as well. That means this fundamental right to equality under Article 14, is not only available to the citizens of India, is available to the aliens as well, to foreigners as well. So if you are from Pakistan, Afghanistan, Bangladesh, but if you belong to Hindus, Christians, Buddhists, Jains, Parsis and Sikhs, for them you have a protection under this law, but Muslims are excluded. Since this law excludes Muslims and includes the religious minorities, as such it is violative of Article 14. But maybe it is not. Because Article 14 does not only talk about equality before law, it also talks about equal protection of the laws. What it talks about? Intelligible differentia. It can create 2 classes of people. On one side, we have Hindus, Christians, Buddhists, Jains, Parsis, and Sikhs. On the other side, we have the Muslims. If this classification is reasonable, Article 14 is not violated. And how is this classification reasonable? Because all these are religious minorities in these countries. This is a religious majority in these countries. These are being victimized. These are being persecuted because of their religion. But these individuals are not persecuted because of their religion. As such, what the law is doing, it is classifying people into 2 groups. Those who are included, those who are excluded. If this classification is reasonable and there is a nexus with the objective, what is the objective? We want to give them citizenship. And we don't want to confer citizenship on them. If this classification is reasonable and the objective is to grant citizenship to them, so there is a nexus. Why we are creating such a classification? Because our objective is to grant them citizenship. as such, Article 14 is not violated. Repeat, Article 14 talks about equality before law. And Article 14 is applicable to citizens as well, to foreigners as well. But if you are from Pakistan, Afghanistan, Bangladesh, and you belong to the 6 religious minorities, this law gives you protection, but it excludes Muslims. Does this law then violate Article 14, violate equality? Prima facie, yes. On the face of it, yes. But as you dig deeper, Article 14 also talks about equal protection of the laws, wherein you can create 2 classes. Intelligible differentia. You can differentiate between 2 sets of classes. Those who are included, those who are excluded. If this classification is reasonable, the law is not violative of Article 14. And what is this law trying to do? It is trying to give citizenship. If that is the purpose, if the purpose is to grant citizenship, for that you are classifying people reasonably, then Article 14 is not violated. Article 14 would have been violated if this law would have said only Hindus will be given citizenship and not the other religious minorities. Then this classification is not reasonable, because here you are classifying people based on their persecution. These people are being persecuted because of their religion. These people are being discriminated because of their religion. But if you include only one persecuted minority and exclude others, then it is not a reasonable classification. Article 14 would have been violated. So one argument in favor of this law is that this law is there to confer citizenship. This law is not there to deprive Indians of their citizenship. So Indian Muslims should not be wary of this law. Second, Article 14 has not been violated. Third, there is a difference between persecuted religious minorities versus victims of ethnic violence. Critics would also say, why are you focusing on Pakistan, Afghanistan, Bangladesh? Why not turn your attention to Sri Lanka, where Tamils have been persecuted? But Tamils have been persecuted, yes, but not because of their religion. They have been persecuted because of their ethnicity. Because for a long time, LTTE was fighting for a separate country for Tamil Elams, a separate Elam, a separate country for Tamils in the northern and eastern part of Sri Lanka. And this war on LTTE could only end in 2009. And it is the policy of the government of India. It's a policy matter. Right now, the government wants to focus on those who have been persecuted because of their religion. That doesn't mean we will discount ethnic violence or people who have been subjected to ethnic violence. It's just that right now our focus is to protect those who are being targeted because of their religion, to give protection, citizenship to those who are persecuted because of their religious identity. Because there is a difference between those who are persecuted because of their religion and those who are persecuted because of their ethnicity. So the Sri Lankan Tamils were being persecuted not because of their religion, but because of their ethnicity, because of their language, because the Sinhala majority would dominate the Tamil minority. And this law is specifically focusing on persecuted religious minorities and not focusing on those who have been persecuted because of their ethnicity. And again, it is the policy of the government. And in policy matters, the courts cannot interfere. Separation of powers. Something else. Article 11. Kapil Sibal, one of the opponents of this law, he said in Parliament that Parliament should not be even discussing this law because this law is so bad to be even discussed by the Parliament. But what is so bad about this law? Dr. Ambedkar, while debating Part 2 of the Constitution, provisions related to citizenship, he said it is not the objective of this Part 2 of the Constitution, to lay down a permanent law for citizenship. To lay down a law for citizenship, that is the power which is available to the Parliament. And Parliament has used Article 11 to enact Citizenship Amendment Act in 2019. That is within the powers of the Parliament. That is the ultimate role and objective of the Parliament. to legislate, to make laws on any item which is mentioned in citizenship. These were the arguments in favor of this law, but then there is also criticism. Criticism that this law violates secularism and as such violates a basic structure of Indian constitution and as such should be declared unconstitutional. How does this law violate secularism? By making religion as a qualification for getting citizenship. The moment you make religion as a qualification for getting citizenship, you're violating secularism, which means this law is similar to the Israeli law of return, where in Israel, if you are a Jew, no matter in which country you are a part of, you are residing anywhere in any part of the world, but if you are a Jew, Israel is your natural home. You can go to Israel and obtain citizenship. If you make religion as a qualification for citizenship, that violates secularism. But then there can be a question on your mind, sir, how could the government then provide benefit and citizenship to these persecuted minorities from Pakistan, Afghanistan, Bangladesh, belonging to the 6 religious minorities, without enacting such a law? Even without enacting this law, or even without mentioning the religious minorities, without mentioning the religion, you could still have done the same thing. You could still have provided the benefit. You could still have granted the citizenship to the same set of people without mentioning religion, without violating secularism. How? Same argument. Article 6 of the Constitution. When permit system was introduced, there were 2 ways of migration. From what became Pakistan, migration started from that country to India. And we overwhelmingly accepted all these people because predominantly these were the Hindus and Sikhs. But when the next wave started, and this time the Muslims were coming from Pakistan back to India, we introduced a permit system. Without the permit system, you cannot register for the citizenship. You could have mentioned in the law the same language because the law does not talk about religious persecution. If the objective of this law is to safeguard those who have been the victims of religious persecution, but this term, religious persecution, is not mentioned anywhere in the law. Nowhere does the law talk about religious persecution. Although in the statement of objects and reasons, when this bill was introduced in the parliament in 2019, there was a mention of religious persecution, but not in the text of the law. What the parliament could have done, those who have migrated to India on or before December 31, 2014 from Pakistan, Afghanistan, Bangladesh, but who have fled these countries because of religious persecution, those can apply for Indian citizenship without mentioning Hindus, Christians, Buddhists, Jains, Sikhs, Parsis, and excluding Muslims. The impact would have been the same. But if you make religion as a qualification for citizenship, you are violating secularism, which is part of the basic structure, and this law as such is unconstitutional. Country-based classification. Article 14, we discussed previously, is not violated by Citizenship Amendment Act because Citizenship Amendment Act classifies 2 set of people, and this classification is based on the objective of the law, which is to provide citizenship. So there is a nexus between the objective of the law and the classification. So as such, Article 14 is not violated. But Article 14 also talks about right against arbitrariness. The law should not be arbitrary, without any logic, without any basis. Sir, what is arbitrary in this law? December 31, 2014. Why this cutoff date? Why, if you have entered India on or before December 31, 2014, You will not be deemed as illegal migrant, which means you are eligible for citizenship. Why this specific date? Why not some other date? You have to provide us the reason. This seems to be an arbitrary date, as such unconstitutional. Number one. Number two, why only these three countries? Pakistan, Afghanistan, Bangladesh. The government will be asked by the courts, why did you specifically choose the three countries and the religious minorities from these three countries as eligible for citizenship? The government may say that we have chosen these countries because these countries have a state religion. Islam is the state religion of these three countries. And the counter is, why not Myanmar, which also has a state religion? Why not Sri Lanka, which also has a state religion? So the manner in which you have chosen these three countries is arbitrary. As such, Article 14 is violated. Why have you only focused on Hindus, Christians, Sikhs, Buddhists, Jains, Parsis? Does that mean only these are religiously persecuted? Have you heard of Rohingyas of Myanmar? Rohingyas, who are predominantly Muslims but are Hindus as well, they have been facing worst form of persecution at the hands of military junta in Myanmar. Why did you not include them? Why did you exclude them and include only these 6 religious minorities from 3 Islamic countries? It primarily means that your decision is arbitrary, your law is arbitrary, your provisions are arbitrary, as such violative of Article 14 of the Constitution. There can be a counter here as well. Rohingya may not be a religious minority. They may be an ethnic group as well, because Rohingyas are both Muslims as well as Hindus, but predominantly Muslims. So on this ground, since this classification of countries seems to be done in an arbitrary manner, where you're excluding some important neighbors, for example, Sri Lanka, for example, Myanmar, but you're including only these 3 countries, since this is done arbitrarily, it is violative of Article 14. Something else, and this is why Assam is on boil. In Assam, there was a long history of illegal migration. People migrated to Assam from Bengal, from East Pakistan, and various other states and territories in India. At one point in time, the tribals from Jharkhand and Chhattisgarh also. And this affected the demography of Assam. And this is the problem that we see in Tripura as well, where at one point in time, Tripura was a tribal dominated state, but now it is a tribal minority state, where it is the Bengali speaking population which have now controlled the majority. Whether that is correct or incorrect, I don't know. This is what the critics are saying. This is what the protesters in Tripura are saying. But the point is Assam, the protesters said that our demography is in danger. Our demography has been altered. Our culture is under assault. And then a massive movement started in Assam from 1979 till 1985. This movement was led by the students under the body called All Assam Students Union, ASU. Their principal objective was that all those who are the illegal migrants in Assam, those illegal migrants are to be identified, arrested, and deported. We have to stop illegal migration into Assam because it is affecting our culture, it is affecting our identity. And ultimately, a compromise was reached in 1985 when Assam Accord was signed between the government of India, Rajiv Gandhi then was the Prime Minister, the government of state, the state of Assam, and the protesters led by All Assam Students Union. And for that, some important provisions were mentioned. Listen to me carefully. If you have entered Assam before January 1st, 1966, we have no problems. You are the citizens of India. you are the residents of Assam. But if you have entered Assam after 1st Jan 1966 till the midnight of 25th March 1971, you are allowed to stay, but you won't get political rights for 10 years. That means for 10 years, you cannot contest elections. For 10 years, you cannot vote in the elections. And after this 10-year period is over, you will have to then register as the citizen of India. You have to register for citizenship. But whoever has entered Assam after 25th March 1971, those are to be identified, arrested, and deported. What happened on 25th March 1971? Operation Searchlight was launched by Pakistani army, where Pakistani army wanted to kill, torture those who were supporting Sheikh Mujibur Rahman, who were supporting democracy in East Pakistan, who were against West Pakistan. And Pakistani army launched this attack, launched this Operation Searchlight, because of which there was massive migration of people from East Pakistan to India. And ultimately, after the war of 1971, which India helped win, Bangladesh emerged as an independent country. But whoever has entered Assam after 25th March 1971, those are to be identified, arrested, and deported. But look at the problem here. Assam is the only state in India which has a different cutoff date for citizenship. Otherwise, the cutoff date is if you have entered India before July 19, 1948, you are the citizen of India. But for Assam, it is a different cutoff date altogether. If you have entered Assam before 25th March 1971 or before 1st Jan 1966, you are the citizen. If you have entered between these dates, then you are eligible to register for citizenship. But for 10 years, you will claim no political rights. You can't vote, you can't contest. But whoever has joined or entered Assam after 25th March 1971, those are to be identified, arrested, deported. And for this, we need to implement Assam Accord. And for this, we need to implement something which is known as NRC, National Register of Citizenship. It is this NRC which contains the details of all the citizens of India. Here, this was first updated in 1951. Matter went to the Supreme Court. Justice Ranjan Gogoi, Justice Rohinton Fali Nariman were the judges. A petition was filed saying Assam Accord has not been implemented. On the directions of the Supreme Court, NRC was carried out in Assam. The report, the findings were published few years later. And when this NRC was carried out in Assam, 1.9 million people could not prove citizenship. That means 1.9 million people in Assam, they could not prove that they are the citizens of India. They could not prove that they have entered Assam before January 1st, 1966. And ultimately, all these 1.9 million people, their citizenship is under doubt. These are doubtful citizens. Now, why is Assam protesting? Because for Assam, the cutoff date was January 1966 or maximum 25th March 1971. But now Citizenship Amendment Act says it is December 31, 2014. Whoever has entered India on or before December 31, 2014, you are eligible for citizenship. Since it violates Assam Accord, that is why there are protests in Assam. And who talks about these different cutoff dates for citizenship? 1966, 1971, Section 6A of Indian Citizenship Act of 1955. And on 12th of December last year, in 2023, a 5-judge constitution bench of the Supreme Court has heard the argument, completely heard the argument, as to whether this section 6 capital A is constitutional or not. Since you're having a different cutoff date for Assam, different from the rest of the country, is this constitutional? A 5-judge bench of the Supreme Court, headed by the Chief Justice, has heard these arguments. Now this judgment can be given at any point in time. Not just this. The reason why there were protests against Citizenship Amendment Act is not because it wanted to provide citizenship to those who are facing religious persecution, the 6 religious minorities from Pakistan, Afghanistan, Bangladesh. No. It was because of some chronology which was used, called CAA plus NRC. NRC, when it was carried out in Assam, how many people could not prove their citizenship? 1.9 million. The then Home Minister, Mr. Amit Shah, said, we will implement NRC in the entire country. That means now in the entire country, maybe 30 million people will not be able to prove their citizenship. And these 30 million people can be Hindus, Christians, Buddhists, Jains, Parsis, Sikhs. And these people can also be Muslims. But Hindus, Christians, Buddhists, Jains, Parsis, Sikhs, they need not worry. Why? Because if they can't prove their citizenship, they can get citizenship through CAA. And once they get citizenship through CAA, their names will be mentioned in the National Register of Citizens, which means they are the citizens. Which means the only community then which is left out are the Muslims. That is why there were protests in different parts of the country, particularly strong protests at the Shaheen Bagh in Delhi, where the Muslims claim that we are being disenfranchised because of this deadly combo of CAA plus NRC. But something else. When we say classification has to be reasonable, that means who is included, who is excluded. This has to be done reasonably. There has to be no arbitrariness in this classification. Why are Jews excluded? Why are atheists excluded? The very reason or the very fact that Jews and atheists are excluded from this group, which will be given citizenship, means that this is arbitrary. Otherwise, Jews should normally have been part of this classification so that they are also eligible for citizenship. Atheists, because of their disapproval of religion, because they reject religion, that is why they are being persecuted in Pakistan, Afghanistan, Bangladesh. That's a reality. So even atheists are persecuted because of their religion, and their religion is no religion. Their exclusion means that this list is not reasonable. But something else. What are these rules which have now been notified by the government? Because what is the need for these rules? Parliament enacts a law, a broad law, a skeletal law. How to implement this law? Rules are to be made by the government. Rules are to be made by the executive. And once these rules are made, these rules are placed before a committee called Committee on Subordinate Legislation. That is something very important for your exam. Normally, within 6 months of the enactment of the law, rules should be made. But these rules were not made. And then the criteria is, if the rules are not made, then you have to seek extension from the Parliamentary Committee on Subordinate Legislation. And this committee has given 8, 9 extensions, and finally yesterday the rules were notified. What is the need for these rules? Because how do we identify that you are indeed from Pakistan, Afghanistan, Bangladesh? For that we need rules. How would you identify that you are indeed Hindus, Christians, Buddhists, Jains, Sikhs, Parsis, and not Muslims or Jews or atheists? For that there have to be rules. How do we know that you have entered India on or before December 31, 2014? One lady who recently came to India from Pakistan and married an Indian in Noida, UP. She has praised the government for enacting this law, but you are not the beneficiary of this because you have entered India after December 31, 2014. That is why we have rules. And now let's quickly look at what these rules talk about. Previously, Indian citizenship could have been given if you had a valid passport or valid visa. For example, Adnan Sami had a valid passport from Canada, had a valid visa from India. That means you are allowed to stay in India. On that basis, citizenship can be given under naturalization. But for these people, even without producing a valid passport, a valid visa from India, which means they are illegal migrants, even without these two travel documents, you can be given citizenship. How? Any document. Because valid passport would have given us a clue that you are from Pakistan, Afghanistan, Bangladesh. Now, how would we prove? How can we prove? Or how can you prove that you are from Pakistan, Afghanistan, Bangladesh? Any document that can show that your parents or your grandparents or your great grandparents were once the citizens of these countries. That is sufficient enough to prove that you are also citizen of Pakistan, Afghanistan, or Bangladesh. And what is this any document? It can be a birth certificate, educational certificate, any identity document, any license, any certificate, any document from these countries which can prove that you were their citizen. That is sufficient proof that you are from Pakistan, Afghanistan, Bangladesh. Or any document that shows that either of the parents or your grandparents or your great grandparents, they have been the citizens of these countries. Any document that you can show, that would be acceptable. Not just that. Government has also done away with the requirement of producing a certificate from an educational institution to get a sense that you have the knowledge of any language mentioned in the 8th schedule. I told you previously, you can be eligible to become the citizen of India through naturalization, but for that there are various conditions that you need to fulfill. And one such condition is you should have the knowledge of any Indian language mentioned under the 8th schedule of the Constitution. And previously, how could you prove that you have the knowledge of any language mentioned in the 8th schedule? You can show your educational certificate, the school certificate, where one of the subject is Hindi or one of the subject is any Indian language, which means you have the knowledge of this subject. Now, for these people who come from Pakistan, Afghanistan, Bangladesh, who belong to the 6 religious minorities of these countries, who have come to India on or before December 31, 2014, this certificate is not required. They can only declare. They can only declare that they are able to speak this language. That is enough. That satisfies the fact, the rules that you should have the working knowledge of any of the language mentioned in the 8th schedule. You don't need to produce this document. Your own declaration, attested declaration, would be sufficient enough and would be accepted as a proof. But how do we ensure that you are the one who has entered India on or before December 31, 2014? For that, listen to me carefully. There is one such thing called NPR, National Population Register, which is normally conducted in the first phase of census. This was done for the first time in 2010, then it was updated in 2015. It was sought to be conducted in 2020, but it got delayed because of the COVID-19 pandemic. What is NPR? NPR contains the details of all the usual residents of India. Who are the usual residents of India? Those who are staying in India for 6 months and those who wish to stay in India for 6 months. 6 months or more. Those are the usual residents, which means these usual residents can be citizens, can be aliens as well. When is this NPR carried out? This NPR is carried out in the first phase, the house listing phase of census. Census is carried out every decade, except this decade where it got delayed because of the COVID-19 pandemic. But when this first phase of census, the house listing phase, is conducted every decade, the census officers would have reached these people as well. They would have asked this question: from when were you residing in this particular area? And are you going to reside in this area for the next 6 months or not? That date which you can show, this slip which you can show, which is given by this slip which you can show, which is given to you by the census officers. If you can mention this to the authorities, we can get to know whether you have entered India on or before December 31, 2014, or any other document, which can be post office account, which can be Aadhaar, because Aadhaar is not a proof of citizenship. Aadhaar is only a proof of identity. Aadhaar only proves that X is X, nothing more, nothing less. Even every usual resident is eligible for Aadhaar. You may have an Aadhaar, you may have a PAN card, you may have any document which you can show when that document was created, which can be shown as a proof that you have entered before December 31, 2014. But not just this. One important aspect of this law, which also raises questions on federalism. In distribution of powers, citizenship is under union list. That means only the parliament has the power to enact laws on citizenship. Clearly, Constitution under Article 11 gives this power to the parliament. But when a law is passed by the parliament, it becomes an obligation on the states to implement that law or not impede the implementation of that law. When the CAA 2019 was passed, various state governments, for example, West Bengal, for example, Telangana, for example, Kerala, they said we will not implement CAA. But not implementing CAA is not your choice, is not an option. You have to do this, otherwise the central government or the president may believe that there is breakdown of constitutional machinery in the state. President's rule can be imposed in your states. But now what the government has done, it has taken a non-confrontationist route in citizenship matters. Because previously, who could have given you citizenship? You had to approach the district collector, the district authorities. And this district collector is under the control of the state government. But now what these rules say, they have more or less bypassed the states. Because earlier citizenship applications were made to the district collector, who was under the or who is under the administrative control of the government. What these CAA rules say, they say now we will have an empowered committee and a district level committee. And who will set up this committee? Center. For what? For receiving these applications. And to receive these applications, we will do it electronically, which basically means now states will not be part, or state officers will not be part of granting citizenship. Although previously the district collector was the single most important officer at the district level in citizenship matters, on citizenship matters. These are the important rules which have been notified by the government, and this gazette notification says the moment this gazette is published, that will be the implementation date of this law. And now this law is implemented. That is all that you needed to know regarding Citizenship Amendment Act of 2019, regarding the concept of citizenship, regarding Assam Accord, some brief history of NRC, and the brief idea about these rules notified by the government yesterday. And if you have liked and enjoyed the session, got benefited from the session, please do not forget to press the like button, drop in your comments, and see you in yet another episode of The Nuanced. Till then, have a great time. Bye-bye.